heal and grow.
All right, we're going on the record in the matter of Matthew Gross, 2335A. And appearance, counsel?
Your Honor, David Drew on behalf of Matthew Gross.
Good morning. And Ms. Taylor?
Good morning, Your Honor. Billy Joe Taylor, P number 82278 on behalf of the people, City of Wyandotte.
All right, thank you. Mr. Gross, your name, please.
Matthew Gross.
All right, thank you. All right, and so today's the date for a motion hearing. Mr. Rudoy had filed a motion requesting modification of probation to allow the use of marijuana for medical purposes. And Mr. Rudoy filed a motion and Ms. Taylor filed a response. And Mr. Rudoy, you may proceed.
I come to the podium, Your Honor.
Absolutely.
So, Your Honor, at the time of sentencing, this issue did get brought up. Your Honor had indicated that if defendant were able to provide a letter from a treating physician, primary physician, that you would allow that medical use of marijuana. The indication was that was the policy within this court. Mr. Gross had attempted to get such an appointment. He had an issue with not having insurance at the time, and currently has been struggling to get an appointment that fits with his work schedule and his responsibilities to probation. I would just note he is successful thus far in his probationary term with no issue. The reason for filing this motion is because Mr. Gross has been suffering without the use of his medical marijuana and has been unable to secure set appointment with the primary care physician. Your Honor, I do believe that under the law and the case law cited in my brief, it is clear that the requirement for a letter from a primary care physician would be in contradiction with the Michigan Medical Marijuana Act and the case law that's coming out of the Michigan Medical Marijuana Act.
In which regard specifically? How is that in conflict?
Okay, so
the court's not preventing your client from using marijuana for medical purposes, but the court does have discretion to make sure that it's for medical purposes, as he's indicating.
Very well, Your Honor, and I'll get to exactly why that's in contradiction of the law.
Okay.
So the Michigan Medical Marijuana Act says to receive Section 4 immunity, which would be what's at issue here, Section 4 immunity. That there is a presumption of medical use and a presumption of everything that the court is wondering about simply by having the card itself. As long as you're not outside of the volume limitations and you have the card, there's a presumption of medical use. In the case of People v. Dewey, which is the case, the presiding case over this issue, I would just note to the court, the court said a condition of probation prohibiting the use of medical marijuana that is otherwise in accordance with the MMMA is directly in conflict with the MMA and is impermissible. The MMA does not have any requirement, Your Honor, that to use medical marijuana, you have to have a card from a primary care physician, or you have to have a letter from a primary care physician. The MMA only requires the card and that you be within your volume limitations. So by setting a bar that is higher than the Michigan Medical Marijuana Act, as far as, because currently, if you were not on probation, Mr. Gross could use medical marijuana.
Or he could use it recreationally as well, correct?
But specifically, I'm talking about the Michigan Medical Marijuana Act. So currently, he would be allowed to. So his use would otherwise be in accordance with the MMA. But Your Honor is saying unless he presents further information that you're restricting his use of the medical marijuana. And so that's directly in conflict with that quote in the People v. Thuy, which I quoted directly. Any condition of probation prohibiting the use of medical marijuana that otherwise would be in accordance with the MMMA is impermissible. I would note that in People v. Thuy, the only thing needed for that opinion to come out was simply the medical marijuana card.
Okay. I'm sorry, and in Thuy, did the defendant have a valid medical marijuana card when he was placed on probation or no?
It is irrelevant, Your Honor. It's not even discussed in the case. The only question discussed in the case is, did he have a card? Was there anything to rebut the presumption of medical use? No. Therefore, no further evidence was required. And that goes at length. And then I would like to just get to, I think this is very important, Your Honor, because the Michigan Supreme Court has tackled this issue as well. This idea that judges have that the cards aren't valid or it can't be trusted. The card itself can't be trusted because of rumors that people get cards impermissibly. We'll say that, or even experiences that people may be getting cards impermissibly. And then Hartwick-Tuttle is the case that discusses this issue. And the court stated in Hartwick-Tuttle that the identification card, this is Mr. Gross's identification card in my hand, is prima facie evidence that because the state has already reviewed of all the things in the application materials, including the bona fide physician-patient relationship, because the state is already required to review all application materials before granting a registry identification card, is therefore presumed that the information contained in an application has been reviewed by the state and the granting of the card is sufficient evidence to demonstrate the card was issued for a valid medical condition following a physician assessment. And that's where there's a presumption of everything that Your Honor would be looking for in this letter is the Michigan Supreme Court said Your Honor should presume that that's all there because we trust the state of Michigan to not only license the doctor, the state of Michigan is aware of that doctor's licensure status, and we trust the state of Michigan to issue a valid medical marijuana registry identification card. We have that, and the law states that once that card has been issued, all of this is pursued. So unless there is evidence to the contrary that the card was not valid, there can be no further requirement, because any further requirement would contradict the holding in Thuy that says if it would otherwise be permissible under the Michigan Medical Marijuana Act, the court may not restrict. There cannot be a condition of probation that restricts it. And I understand, and I respect what Your Honor's intentions are here. You're trying to make sure that people are using validly. However, I think in this particular case, I would ask Your Honor to follow the law. I believe that the law requires the court, if there's a valid card, obviously his order has to be to use medical marijuana in accordance with the Michigan Medical Marijuana Act. Can still be part of the probation order, but I do not believe that there can be this additional requirement. And there is, I would just note for Your Honor, there's absolutely no requirement in law that it be a primary care physician recommending a medical marijuana card. So the state of Michigan, this system has existed since 2009. The state of Michigan has amended the Michigan Medical Marijuana Act 3 times. They actually visited this issue more recently, the legislature, and found that based on after THUI, which was the case that basically said if you have a card you can use on probation, as long as you're in accordance with the Michigan Medical Marijuana Act. The legislature revisited this and they actually amended the Michigan Medical Marijuana Act to say not if you're in a sobriety court or drug treatment court probation, and that it no longer applies. So they could have amended the law to say that there should be a requirement of a primary care physician's letter or other requirements. However, the legislature looked at this issue and did not amend those issues and only amended it in reference to treatment courts. So I do believe Mr. Gross has been a Michigan medical marijuana patient dating back to 2010. I just would like to offer this letter to your honor. This is a letter that prior to the ruling in THUI that Mr. Gross got on a previous probationary term. That is a letter from a doctor that outlines the medical necessity for his medical marijuana use. It is dated from 2017, but that's the last time he was able to get such a letter from a doctor.
Okay, that's actually a very good letter.
So, Your Honor, what I'm asking for today is in this particular case, to allow Mr. Gross the medical use of marijuana with his valid card. Obviously, the use must be consistent with the laws and rules surrounding the Michigan Medical Marijuana Act.
Okay, so I do have a couple of questions before Ms. Taylor proceeds. So, and just to be clear, if whether it's a primary care physician or a treating physician, if Mr. Gross has medical issues, doesn't he have a treating physician or a doctor that he sees on a regular basis?
Yes, Your Honor, but to get his new card, I would just note, the prior doctor that he was seeing, he got his renewals from the same doctor for a number of years, from 2010 until I believe 2021, approximately. That particular office closed. He did see a new, and he developed a bona fide physician-patient relationship with a new physician. We had asked them about writing a letter for this court related to this case, and the cost of getting that letter, that they, doctors are going to charge for their time, and it was not covered under insurance, and there was a large cost of getting that letter. We weren't sure if Your Honor would honor that because it is coming from a specific type of clinic. And so Mr. Gross felt better to just file the motion with Your Honor today rather than spend those funds on, or spend funds on getting a letter from the doctor. So he is seeing a physician for related to the medical use of marijuana, and he did contact that physician and talk about getting a letter written, and he would have been charged for such.
What was the cost of the letter?
I'm speaking off of memory, but I believe they asked for $400.
For a letter?
Well, for a letter that was fully outlining all of the stuff there. All similar to the letter that was previously written by his prior physician.
And how long has Mr. Gross been treating with that physician?
This new physician?
Yes.
Your Honor, I believe over the course of the last 6 months.
Okay. And so the doctor that had renewed the card or the prescription or what have you, for Mr. Gross from the years 2010 to 2021, how often did Mr. Gross see that physician? Did you see him monthly, twice a year, or only when you needed to renew the card?
Your Honor, I believe at different times, you probably saw him more often and less often. I don't believe that is relevant for the motion that's at issue today. To get into his entire medical history, a doctor saw him, a doctor filled out the paperwork that's necessary for the state of Michigan to make a determination of whether or not to issue a card, and a card was issued. A card was issued that the Michigan Supreme Court stated that courts around the state must make a presumption based on this card being issued, that the use is valid, just like an officer seeing somebody possessing marijuana on the street. If somebody has a card, must make presumptions based on that card. This card is afforded weight and it's issued by the state of Michigan. Just as a lawyer has a license that's issued by the state of Michigan, you presume that I know how to practice law. This card also has the weight of law behind it as well.
Well, I presume that and not just you, but I presume any attorney that has a P number licensed by the state of Michigan, it doesn't necessarily mean that they know how to practice law. As I think we've learned over the number of years. I'm not suggesting that for you, I'm just indicating.
I understand what you're saying.
The court doesn't make that presumption, but.
I guess my point is, Your Honor, the court in Hartwick-Tuttle looked at this particular issue and said, the state of Michigan's reviewed everything. We have to trust the state of Michigan to do the proper review in issuing a card and determine that this person is eligible and shall receive immunity under the Michigan Medical Marijuana Act when they receive that card. And that presumption should be there unless there is evidence to the contrary, which I believe based on the people's response, there is none. There is no reason to go through Mr. Rose's 11-year medical history with his prior doctor and how often did he see them, he had valid cards.
Because I'm not asking you to go through his medical history. I'm trying to establish one of the concerns that this court has seen that is not unique to this court. And so that's why I asked some of the questions. I'm not asking to get into his medical history specifically.
And
I'm just getting into whether or not Mr. Gross only saw that doctor that issued the card when he needed the card issued, or if he saw him on a somewhat regular basis to have some type of treating relationship. Because here's,
Your Honor,
we're talking about marijuana, it's as a medicine, okay? And so when it's issued as medicine, I liken it to blood pressure medication, insulin, any, pain medication, anything that's prescribed, okay? And so a doctor isn't prescribing that. Someone's not typically walking into a random clinic and getting prescribed that on a regular basis, okay? So that is why I'm asking some of my questions.
Your Honor.
And I understand the Medical Marijuana Act. I absolutely do. If somebody is prescribe a medication, then it's prescribed by somebody that they have a treating relationship with, so that there isn't something prescribed that's going to interact in a negative manner with other medication.
Are you finished, Your Honor? I'm sorry.
No, but go ahead.
I just, a couple things to know. Medical marijuana is not a prescription in the state of Michigan. For even for prescription drugs, there was not a ballot initiative voted on by 63% of the voters of Michigan that said that if you qualify, that you should receive immunity from penalty in any manner. That doesn't exist with prescription drugs. It's not a prescription drug. Part of the reason that it was never made as a prescription, there are prescriptions that contain THC, is the conflicting with medical law or federal law, because the doctors have controlled substances licenses that are issued by the federal government. And so rather than prescribe, which means to tell somebody to do something, that could cause some issues with their federal controlled substance license, and no doctors would ever write it if they're at issue of losing their controlled substances license. So that's why the law was written in a very specific manner. However, what Your Honor is getting into, and the territory that we're getting into, is relevant to an area of the Michigan Medical Marijuana Act, which is Section 8 of the Michigan Medical Marijuana Act, which is the affirmative defense provision. That's for when somebody is outside of the protections of Section 4 of the Michigan Medical Marijuana Act, where the relevancy of a bona fide physician-patient relationship, although there is still a presumption by having the card, but that becomes a relevant element in analyzing Section 8 of the Michigan Medical Marijuana Act. But what we're talking about here is Section 4 of the Michigan Medical Marijuana Act. Section 4 of the Michigan Medical Marijuana Act essentially has 4 elements, Your Honor, and those elements are: do they possess a valid registry identification card? Is the first element. The second element is are they within their volume limitations? With which Mr. Gross is not possessing. I'm sorry. Mr. Gross is not possessing any marijuana currently, and obviously moving forward in the future, he would have to. Are there plants kept in a locked and enclosed place, which there are no plants, and he's not asking for the ability to have any plants. Is it for medical use? And there's a presumption by having the card and being within the volume limitations that it's for medical use. If you look at page 7 of my motion, the case of Hartwick v. Tuttle, Michigan Supreme Court cites these 4 factors that are to be considered, and they're listed. So, Your Honor, the analysis of whether or not there's a bona fide physician-patient relationship that you are asking questions about, and I understand why you're getting into it, but I don't believe it's relevant for the motion at hand today.
All right, Ms. Taylor, your responses.
No responses, Your Honor. The prosecution leaves it to the discretion of the court.
And so, counsel, your position is based on the MMA Act and case law, the court has 0 judicial discretion. Is that your position?
When it comes to, so no, I don't, that is not my position. When there is evidence that the court knows of that would rebut the presumption of medical use, then the court does have discretion to weigh in on this and to hold it, for example, an evidentiary hearing. When there is evidence of that, Your Honor. In Mr. Gross's case, so I don't believe there is zero judicial discretion when it comes to that. And I have been in courts where I have argued, I believe it's appropriate to have an evidentiary hearing on this matter, because there is some contradictory evidence, right? That the use was not for medical purposes. However, in Mr. Gross's case specifically, I know that he has been passing all his marijuana tests. He has complied with the court's orders. There is no marijuana involved in the case at bar. And there is literally, I know there could be no evidence to rebut the presumption of medical use because he literally has not been using. He has been waiting for this court to grant a request to use and following this court's orders. So I believe in Mr. Gross's case, there's not a discretion there's no reason to hold an evidentiary hearing as there is a presumption and no evidence to the contrary, and we've met the other burdens.
And so what would be an example of some evidence to rebut the presumption?
Evidence to rebut the presumption. One could be found in the PSI report. When you're getting into the PSI report and you're getting to, now under Harwick-Tuttle, I want to be very careful here and not misrepresent things to the court. Under Harwick-Tuttle, there is no bursting bubble. So even if you had previously used not for medical purposes, for example, that doesn't necessarily mean your future use is not for medical purposes. I would make it akin to like somebody who took a Vicodin to get high when they were in college, but now just had surgery and need Vicodin, right? It doesn't mean that their current need is offset, but I think that's at least evidence that could call into question the need for an evidentiary hearing. I think evidence, the most likely evidence would be that, when the case itself involved use outside of the Michigan Medical Marijuana Act. For example, under the Michigan Medical Marijuana Act, you may not drive under the influence of marijuana under Section 7. You may not use marijuana, on school grounds or in public, So the things like that, direct violations of Section 7 of the Michigan Medical Marijuana Act, and the court having some knowledge or some history of that, I believe would be areas where the court could potentially inquire. Although there is no bursting bubble, I think that, there at least is some evidence to the contrary. There would need to be found a nexus between those acts outside of the Michigan Medical Marijuana Act and the presumed future use, but I do believe there's still some discretion left to the courts.
So in the PSI report, Mr. Gross indicated that his health was good. No serious accidents or illnesses in his past. And so this letter from 2017 for the medical purposes would indicate that he had some chronic lower back and neck pain.
And Your Honor, I would just note,
related to an injury that occurred as an adolescent when he was hit by a car while on his bike.
I did make that correction on the record at the time of sentencing, Your Honor.
Okay, I don't have that note on there. The only note I have is that he previously used medical marijuana for severe chronic severe and chronic back pain.
I did bring up on the record at the time of sentencing, at the time of the
Yeah.
suicide, that he had been hit by a car. He was on a bicycle and he was hit by a car.
Okay. And also on his criminal history, he has some prior marijuana felony convictions. 2006,
Your Honor, I don't believe.
2017, the trafficking in marijuana out of Ohio.
Again, Your Honor, I don't believe that those old charges from 6 years ago are relevant to, the question for the court is whether Mr. Gross's presumption that he will use medically during his time on probation is rebutted. And I believe in this particular case, Your Honor, there is no evidence direct that Mr. Gross will not be using his medical marijuana, especially when Your Honor considers that he has been perfect during his time on bond and probation thus far.
So what has your client been using to address his back pain instead of the marijuana right now?
I believe anti-inflammatory medications, Your Honor. Non-narcotic anti-inflammatory medications. He does not wish, he could have, and I would just note this to Your Honor, I discussed with him while waiting for the doctor, you know, the potential for using narcotic pain medications that are prescription, that Your Honor would, you know, probation would allow without a letter. And Mr. Gross just is vehemently opposed to using opiate or narcotic pain medications. It's a personal medical choice of his. He does not wish to engage in that.
All right, and you're still working as a laborer, sir?
No, I'm working on a factory, mixing post. I had to take 4 hours to.
And does work perform drug tests on you? Or not on you, just in general on your employees?
When I got hired, and if you get some.
All right, I'm going to, take some time to, re-review the cases, and I'm going to issue my decision accordingly. Can you return on August 1st?
Your Honor, August 1st, I do have the morning available. Could I make a request, if this is Your Honor, essentially, would Your Honor allow defendant to appear via Zoom?
Yes.
Or waive defendant's appearance so he doesn't have to miss work?
I wouldn't waive his appearance, I would
Allow him to
allow him
appear
under
via Zoom.
Zoom, yes.
Thank you, Your Honor.
Thank you.
Now, evidence you're hearing is not off the table at this point, counsel, but I'm going to review a bit further some additional arguments that you put on the record.
Thank you very much, Your Honor. I appreciate it.
Car get dough. I can't get no sleep, please make my life more simple. Miles inside these shoes so I don't stomp, I tiptoe.